Our final presenter for today is attorney Ellen Cookman, who will be taking us or talking to us about estate planning with siblings in mind. I would like to warmly welcome Ellen to come on camera and introduce herself.
It's such an honor to be speaking. So today we're going to be talking about special needs planning for the entire family. A lot of times when we're looking at planning, we're thinking about our kids with disabilities, but how do our neurotypical siblings fit in? So this is me. So I specialize in estate planning and special needs planning. I'm in Palo Alto, California, but our firm serves everybody all over California. And I have two boys. So this is very particular to me. My older son has high functioning autism, and my younger son is neurotypical. Um, and we think a lot about these things in my family. So I'm really happy to share this with you. And I do see somebody is raising their hands. I'm going to wait until the end of this to answer questions if we have time. And I think you can put the questions in the Q&A section. Okay, so here are our kids, right? So we may have two or more children. Some people have a lot of kids. After two, we were like, we're done. Thank you very much. But one of our kids may not ever be able to leave the home, or they have significant needs, or we don't know if they'll be able to eventually launch fully. And then the other one might be doing really well. Maybe they're living in a different country. Maybe they have their kids of their own. And we want to know, how do we marry these two? Like, how do we help both of our kids to live the most independent, successful lives for themselves and to continue to love each other as much as they can and keep that relationship going? I'm hopeful. So my boys, they get along really well when they're not fighting. We'll just put it that way. So, they're still learning at 11 and 13 how to really get along. So these are the three main things. I'm kind of like getting the punchline. These are the three things that we're going to really zone in on as we look at overall estate planning and special needs planning. One of the big questions that comes up is, how do we allocate inheritance between our kids? Should it be equal? Should it be fair? How do we make these decisions? The next one is, how do we protect our neurotypical kids with their inheritance? And then the third one is, who's going to manage the money that our disabled kid will need? Okay, should it be their neurotypical sibling? Should it be somebody else? What are the options? So those are three of the things that we will be focusing on today. But in order to understand where that goes, I want to kind of give a bigger overview. And so these are the things that we care about the most as parents, as caregivers, as family members. For all of our children, we want to maximize their quality of life. I think that's number one importance. We want to protect our kids from financial predators. We want to maximize their independence, regardless of how independent they're really able to be. We want to maximize our special need child's public benefits. That helps their inheritance stretch a lot longer. Usually that's how they're going to be receiving health insurance, which of course is super important, right? And really we're looking at who's going to be the surrogate financial parents for our special needs child, and how do we set that up? And finally, I'm an attorney, but I hate going to court. So we want to avoid the court system whenever we can. So there's really three subjects that we'll be talking about today. We're going to talk about public benefits, because you really have to understand that in order to see what planning options we have. Then we're going to look at special needs trusts, and then we'll look at ABLE accounts. So first, public benefits. So I want to caution you, the next slide has a lot of information, but we will walk you through it. And this is the best way that I've found to really explain what are public benefits. So the way I think about public benefits is, if you're able to work and support yourself, you get two main things. You get an income stream, which is your salary, and you get health insurance. And it's my hope that someday in the US, we will decouple these two things. So our health insurance is not dependent on our employment. But we're not there yet. We've kind of taken some steps back, which is really discouraging. But I'm still hoping that we'll get there. Okay. So here's the problem. If you're disabled and you can't work and support yourself fully, then what'll happen? You still need an income stream, you still need health insurance, and that's when the government steps in to provide these things. So here's my chart of the four main types of public benefits that you should be aware of. The top two benefits, we call those needs-based because you need them because you're poor. So what that means is you have to have low assets or low income in order to receive them. And then the bottom two we call entitlement-based because somebody paid into the system and now you're entitled to receive them. And then on the left-hand side of this chart are the income streams, and the right-hand side is the health insurance. So let's start with the top left-hand one, SSI, Supplemental Security Income. A lot of your kids may already be receiving this. This is an income stream where you can get up to about $1,200 a month, which supplements any other income you might be receiving. And this is if you qualify as disabled with Social Security Administration. All right. Now, SSI has the most stringent eligibility rules. You have to have under $2,000 of countable resources in order to qualify for SSI. You truly have to be poor. And if you get even $1 of SSI, the good news is you qualify for Medi-Cal, which is California's version of the federal Medicaid system. Now, Medi-Cal eligibility is like it's a moving target. Last year and this year, there was no resource limit. Unfortunately, the resource limit is being reimposed. It used to be $2,000. And in any other state, by the way, it's a resource limit of $2,000, same thing as SSI. But in California, we got rid of it and we were celebrating, and then our celebration didn't last very long because it's being reimposed, but not at the $2,000 limit next year. It's being reimposed at $130,000 per person. And if you have a family of more than one person, then that's increased by $65,000 per family member. Okay, so that's SSI and Medi-Cal. If you receive an inheritance outright, it's going to bump you off SSI and Medi-Cal because probably your countable limit will go above that amount, and that's when we need a special needs trust. Now let me talk about the bottom ones for a minute. Bottom left is SSDI, Social Security Disability Insurance. And this is basically you've worked for a while and then you became disabled. Any of us could qualify for SSDI. Now there's one that's under the SSDI umbrella, which is called Child Disability Benefits. And a lot of families don't know about this. So listen up. If your child became disabled before age 22 and you retire and you're receiving Social Security, your child can get half of what you're getting at the same time that you get the full amount. And when you die, your child can get 3/4 of your income stream. They don't tell you this. They should, but they don't. So definitely look into this if you have retired and you have a child under 22. And then even better, after 2 years of receiving child disability benefits, you qualify for Medicare, which is another health insurance program that everybody age 65 and older qualifies for. But you can be disabled and under 65 and also get Medicare. Let me also point out just the top right-hand corner, IHSS, In-Home Supported Services. That's under the Medi-Cal umbrella. So if your child qualifies for IHSS, you need to follow the Medi-Cal eligibility rules. Okay, so now I want to look at these public benefits from a slightly different perspective because these benefits are not stagnant. They change over time. So when your child is born, they receive different benefits than other benefits that they might receive. So let's look at that timeline. This is one of my favorite things I've created. Okay, so we start at age 0 on the left. Your child is born. They qualify for Medicaid. Medi-Cal is the California's version, right? Under a waiver program. So everybody in California can get Medi-Cal. Then at age 18, your child turns 18, and your money is not attributable to them anymore. So they become poor. They don't have any money, and they can start getting SSI. And then they get Medi-Cal under a different program, because they're receiving SSI. And now they have SSI and Medi-Cal, and time goes along, and then their parent retires. Now the child can get half of what the parent's receiving. They get the child disability benefit, CDB, and after 2 years, they get Medicare. Now time goes on some more. The parent dies. The child might be in their mid-50s. We don't know when, right? Then the child starts getting 3/4 of the parent's Social Security benefits. And then at the end of the time, then the child passes away and obviously the benefits end. Okay, so I like giving that perspective of public benefits so that you kind of see where does that fit when we're doing our planning. So let's talk about special needs trusts. Why do we need them? Well, for a few reasons. We need it to protect the public benefits, those needs-based public benefits. Anything that goes into a special needs trust does not count against that $2,000 limit for SSI or that $130,000 limit for Medi-Cal. So you can have a lot of money in a special needs trust and still receive your public benefits. So it's great. It's like having a safety net. Now, the reason why it works is because somebody else is managing the special needs trust, not your child. Your child can't demand money out of the trust. They can't change the trust. And because they're not managing it themselves, it doesn't count as their money. And we don't want them to manage it. So that's an added bonus. It really adds a lot of protection for the child. If a financial predator comes along and tries to get money from the child can't access the special needs trust. It's a set aside amount for the child's benefit managed by somebody else. Now one fallacy, one fiction out there is that a special needs trust is very restrictive. You can only use it for these few things, and you have to be really careful that, this and that. You can only use it for transportation or, I don't know, adapted wheelchair. That's not true. You see this court case from 2023 that says that special needs really for a special needs trust is intended to pay for the broad range of everything that a human being needs to live, thrive, and realize his or her potential in life. I mean, isn't that beautiful? Isn't that what we want, right? So a special needs trust, it's very broad. You put the money in, the main restriction is the trustee is managing it and is deciding what distributions to make, but you get the right trustee and it works really well. Now there's two main types of special needs trusts out there. There's the trust for that somebody else puts money in for the child, for the disabled beneficiary. And then there's the trust that the child puts their own money in. Now the one that other people put their money in is called a third-party special needs trust because it's talking about the source of the funds. The money is coming from people other than the beneficiary, from third parties. Whereas with a first-party special needs trust, the money is coming from the beneficiary themselves. So for example, the beneficiary was in an accident and got a settlement claim. that money would need to go into a first party special needs trust, or the beneficiary received a $100,000 gift from grandma. Oops, that might need to go into a first party special needs trust. But what we're really envisioning, a lot of, I'm assuming most of the people on this call are caregivers or family members or caregivers are third parties. And so you'll probably be setting up a third party special needs trust for your child. Now, I'll make sure to, we can make these slides available because I have a chart kind of comparing what are the qualifications, when would you use these trusts? So we have the third party special needs trust, money, anyone else's money goes in. You get to say where you want money to go when you die, or when the beneficiary dies, you get to spell that out. First party special needs trust, the disabled person's money goes in, and they have to put the money in before age 65. And when they die, Medi-Cal gets to bring a reimbursement claim against a first party special needs trust, not the third party one, just the first party one. And then after Medi-Cal gets paid back, then the remaining money goes to the remainder beneficiaries. Now, let me acknowledge for a second, I'm going through this really fast because we have a lot more information, but I have a YouTube channel that I encourage you to go watch, and I break down every topic that we're covering today with different videos. So feel free to go and, like and subscribe, right? So, okay, so then the third line there is a pooled trust. This is basically a nonprofit organization that pools together a lot of smaller trusts. So they have, they have a financial advisor helping, a care manager. They're able to create efficiencies because they have a few professionals helping a lot of smaller trusts. So as we mentioned, a special needs trust works really well if you choose the right trustee. And this is the surrogate financial manager, the surrogate financial parent, okay? So when people are thinking of who am I going to choose as successor trustee, usually they think of family members or friends. Those are the people who they're around all the time. They say, oh, I know this person, they're trustworthy, I'll name them. But I'm going to talk about why that may not be the best option, okay? There's other options. There are professionals. One of them are individuals. They're called private professional fiduciaries. In California, we're very lucky. Most states don't have this category, but private professional fiduciaries can be great. Main drawback is they're human, so they might die or retire or resign, but they can work very well as a successor trustee. Also, banks and trust companies can be very good choices. They usually require like at least $1 million under management, so that's not available to some people, but to others, it could be a good choice and they do have longevity. Then there are some nonprofits, and I mentioned pooled trusts. Now, here's something I really want to focus in on because we're really talking about the siblings' role. And you may have a couple kids like me, you have your Caleb, my older son who has high functioning autism, and then Isaac, who's the neurotypical one. And you might think, well, they're older now, maybe, they're 25 and 30 or whatever. And you say, the younger one, they get along pretty well. The younger one, my neurotypical kid can just take care of the special needs kids' needs. I usually recommend against this. And there's a few reasons for that, okay? First of all, managing a special needs trust it's a big commitment. Your disabled child might live for many, many years, and you have to make sure that there's enough money set aside and that it's managed properly to last that entire time. You also have to understand all those public benefits that I just talked about, that maybe that chart kind of scared you. Well, your kid's going to have to take over. The neurotypical kid would have to take over understanding all of that and navigating the system. I've heard estimates that parents doing this work, it usually is like $150,000 a year of all the work that you put in for raising your disabled kids. It's a lot. It's a lot of work. Okay. This can also affect family dynamics. If your kids don't get along so well, or if your disabled kid might grow to resent the neurotypical kid who's the gatekeeper now for their money, and they don't like that. We also want the siblings to go and live their best life. And as I mentioned, there could be siblings who are living in different countries or different states. They might be working really hard and they might have large families of their own. They have a lot of responsibilities. So it's a big ask. It's a big lift to ask a neurotypical sibling to be trustee of the Disabled Sibling Special Needs Trust. I usually discourage that. But here's a role that I think is much more appropriate for the neurotypical sibling. It's a role called a trust protector. So here's how it works. You have a professional acting as trustee, and then your neurotypical child, the trust protector, they get yearly accountings. They're able to review how money is being managed, and they can remove and replace the trustee with a different trustee. So they're kind of the overseer. They look to see, all right, is this working out? What's the problem? They check in with their sibling and they say, how are things going? If you're the disabled person can communicate. And so they're advocating for the sibling kind of like you would do, but they don't have all of those day-to-day responsibilities of managing the money, filing the tax returns, figuring out the public benefits, making sure the caregiving responsibilities, making sure that the child's toenails are clipped, right? All these things that come up when we have kids with disabilities, right? So oftentimes when I propose this to my clients, they are so relieved, and the neurotypical sibling is so relieved that there's a different role for them, that they can still be involved, but it's not as onerous. It's not as stressful. And it allows them to be a loving, caring sibling and not the financial manager. Now, here's a document that I always recommend that parents write. It's a memo of intent. This is something separate from the trust document, but it's basically, Dear Successor Trustee, here's everything I want you to know about my child with disabilities. Here's what makes them happy. Here's what really ticks them off. Here are the extended family members I want them to be in communication with, the ones I don't. Make sure that they get to Special Olympics every year. Everything that you've learned about your child over the years, you're kind of doing a big brain dump into the successor trustee. And you can also have the neurotypical sibling contributing to this, and whoever else is familiar with your disabled child. Now, this slide, I'm talking more about the structure of the trust. So a lot of times you'll find, how do I put this nicely? You find estate planning attorneys who don't really specialize in special needs planning, but they find out you have a disabled kid and they go, oh, don't worry, we'll put in some special needs trust language. We call that a testamentary special needs trust because it's embedded within your revocable trust and it springs into being when you die. Now, I don't think those trusts are very good, and I have two main reasons for it. The first reason, and I think the most important one, is when the trust is funded, Social Security Administration is going to want to see a copy. And if you send them this full revocable trust and you say, see Article 6, that's where the special needs trust is, they're not trained to review special needs trusts. They have no idea what all of this means. And so they look to see, well, wait, who's the successor trustee? That's in Article 3. What's the alternate distribution? That's in Article 10. What? And I've actually had them, I've heard of colleagues where they've come back and they've asked for somebody to cut and paste the sections of the special needs trust. So you just want a standalone special needs trust, just one document to send them. The other reason is that if you have a special needs trust embedded within a revocable trust, as I mentioned, it's not effective yet until you're gone. So if you have a family member or a friend who wants to contribute to your disabled child's benefit, they want to put money into the special needs trust, they can't until you're gone. So if you have a standalone special needs trust, one that's already up and running and effective, they can put money in. Now, you don't need to get a tax ID number if there's no money in there yet. You don't have to file separate tax returns. It's just waiting for a triggering event. It's waiting for money to go in. So I always recommend, or 95% of the time, I recommend a standalone special needs trust. So what can go into a special needs trust? How do you fund these? What is it useful for? Well, you can always put in cash and investments, and usually that's the most helpful because that's accessible, that can be used to pay for things. But a special needs trust can hold a house. It can hold, the inheritances. It can hold retirement accounts too. I've heard life insurance is a very good way to fund a special needs trust because then the money is available when it's really needed when you're gone. So you can name the special needs trust as the beneficiary of a life insurance policy. So there's a lot of different ways to fund or put money into a special needs trust. All right, so this is the second topic that I promised we'd talk about when we're talking about planning with siblings. So the first main thing was who's going to be successor trustee? And here's the second thing. How much do I need to put into that special needs trust, right? Should you just do 50-50 between your disabled kid and the neurotypical kid? Well, sometimes that may not be enough for the special needs kid. But then how much do you need to put in for the special needs kid in the first place? This is something that I recommend you need to do what's called financial projections. So this is looking at, how old your kid is now, how long they're expected to live, what are their needs, okay? If the market goes up or goes down, what is their prognosis? How long are they expected to, all those things. I don't do those. Usually that's financial advisors who do that type of planning. And not all financial advisors do. Usually financial advisors do that type of planning for adults who are retiring. And it's a similar sort of thing, right? Because you look at, okay, if I retire at age 70 and then I live to 95, I have 25 years, need to make sure I don't run out of money. But we're making sure that maybe your 18 or 20-year-old, if they live to 95, they don't run out of money. There's a certificate called a Chartered Special Needs Consultant. That's a financial advisor who does these types of calculations. So I usually recommend to families to get a number, work with a financial advisor to find out how much do I leave to the special needs kid. And then you can do a couple things. One thing is you can just say, okay, off the top, before anything else gets distributed, that amount goes to the child special needs trust. And anything remaining gets divided equally between the neurotypical siblings. Or you can say, well, that amount, boy, that's about 60% of my total assets. And so I'm going to have 60% go to the special needs trust, and then 40% or 20-20 if there's two neurotypical kids. So you can divide it up those types of ways. We always want to treat our kids equally, and they like to be thought of as being treated equally, at least mine do, but they have different needs. And so I think we want to treat them as equitably as possible. We want them to each get the resources that they need to live that full, independent, happy life. All right, so third big topic, how do we protect our neurotypical kids? Because a lot of times they get overlooked. I remember when Caleb got diagnosed, he was 4, and we were going to pivotal response therapy and occupational therapy and all these things. and Isaac would just kind of come along. We didn't really think about his needs so much. So much focus was on Caleb. But we want to protect our neurotypical kids as well. They go through things too. They might get married and then get a divorce. They might have somebody sue them. So a dynasty trust is basically an asset protection trust that can last for the child's lifetime. And it's set aside and it doesn't count as the child's money. So if they get a divorce, it's not split and half goes to the horrible ex-spouse. It stays with your child. If they're sued, we just make sure that they're not managing the trust and there's a high level of protection. Also, any money that goes into a dynasty trust, it can grow and grow and grow, and then it goes to the kids of your kids, your grandkids, free of estate taxes. So that's what it was actually developed, and that's why it's called a dynasty trust, is because it's helping your dynasty to grow. It's helping your assets grow down the generations. But most of my clients are more concerned about the first two protections, about protecting for creditors and spouses. Now, a dynasty trust can be set up for our neurotypical kids, and they can act as trustee of their own trust. You can also set up a dynasty trust for a kid with special needs who doesn't receive public benefits. Maybe they're very high functioning, or maybe they have mental health challenges that are crazily enough not acknowledged by Social Security, or maybe they can work a bit and then they're not able to work, and on and off. A dynasty trust can be a good choice for that. So these are the two types of trusts we really have for kids who have trouble leaving the nest. And the dynasty trust is very good for protecting kids who are very successful, but make sure that that their inheritance is protected for their lifetime. All right, so let's talk about able accounts. So this is different than a special needs trust, but you've probably heard about this. This was really created by, and let me kind of tell you how it was created, and it'll give you an idea of how it's supposed to be used. There was a bunch of parents of adults with Down syndrome who got together, and they were talking, they were in Virginia, and they were saying, it is not fair that our adult kids are working and they have to spend down their money down below $2,000 so that they can still get their SSI benefits and still get Medicaid. And these parents talked to their representative, and their representative proposed the Achieving a Better Life Experience Act, and it passed with bipartisan support. I know we don't hear that very often nowadays. This was 10 years ago when things made it through Congress a little bit easier, perhaps. So it's basically modeled after a 529 plan. This is a savings account that doesn't interfere with public benefits like SSI or Medi-Cal. Now it's set up, well, actually, I'll talk about that in a second. So it functions the way that a 529 plan does, where you put in post-tax money into the account and it grows and grows and grows. And then when you withdraw the money, as long as you're using it for what we call qualified disability expenses, you don't have to pay any of the capital gains tax. So it's a nice savings account. Now here's the main drawback, is that last bullet point here where it says you can only put in up to $19,000 a year. That's at least for 2025. The number is actually the gift tax exemption amount for that year, which this year, it used to be 10,000 and it kept going up and up. This year it's 19,000. We estimate it'll go up to 20,000 next year, but that's how much can go into an ABLE account every year. So that doesn't mean grandma can put in 19,000 and dad can put in 19,000 and other people. Nope. Once 19,000 goes in, it's capped off and nobody else can put in money for the rest of the year. So an ABLE account is not meant to receive an inheritance. It's really meant for smaller gifts. It can also hold the disabled person's own income. So it can receive both the disabled person's money and anybody else's money as well. Okay, so here are some of the rules. Now, one of the rules, so we mentioned it has to be used for qualified disability expenses, and I have a slide about that. But to be eligible, this year you had to have become disabled before age 26, but that's going up to age 46 next year, happily. And the test for disability is not stringent at all. It's like the opposite of SSI, okay? It basically, you need to have a self-serving doctor's letter saying that you're disabled. That's it. Nobody even checks these things. I hope nobody from the IRS is on this. Anyways, nobody checks this, all right? And the disabled person can set up an account for themselves, or somebody else can set it up for them. If somebody else sets it up for them, the person who's managing it is called the authorized legal representative. It's kind of like the representative payee for someone who's receiving SSI or SSDI. As I mentioned, anyone can contribute to this ABLE account, the beneficiary themselves, their spouse, other family members, friends, GoFundMe stuff, but you only get one ABLE account. So you can't set one up in California and one in Ohio and one in Tennessee. You only get one. So what is a qualified disability expense? It's kind of like that definition of special needs trusts. You can use it for just about anything that's intended to improve that person's quality of life. So here's a long list, and the list goes on and on and on. It's just, it's not supposed to be used for what, like illegal drugs or gambling, or, I mean, very limited. Oh, and also it's not supposed to be used for cannabis. I needed to do some research into that because this is a federally based program, but just about anything else it can be spent. Okay, since it's a 529A plan, you can roll over money from a 529 account to an ABLE account, 19,000 a year, or back again from an ABLE account to a 529 plan. And you can do this between siblings as well. All right, so you can say, oh boy, which happens with siblings for a 529 plan. You can roll as much as you want from one 529 plan to another. If we're dealing with an ABLE account, just 19,000. Now, if you're working, if the disabled person is working, they can put in about $15,000 of their own earned income in addition to that $19,000 cap. So now we're looking at about $34,000 that can go in that year, but it's only the beneficiary's earned money that can go in. And that's only if the beneficiary is not participating in their employer's retirement plan, because I think that's seen as, hey, this is retirement money for them. Now, one thing to know is that ABLE accounts were set up to have that reimbursement clause, just like first-party special needs trusts. However, they put in the law that states could waive the right to reimbursement. And California and like 4 other states happily have waived the right to reimbursement. So there's no reimbursement provision if you have a CalABLE account and you are a California resident. Now, or if you're a resident somewhere else, Medi-Cal will not bring a reimbursement claim against a CalABLE account. But here's the thing. If you set up an ABLE account in another state, Medi-Cal can bring a reimbursement claim against that ABLE account in the other state, at least if you set it up before 2023. After 2023. If you set it up before 2023, you're grandfathered in, you're okay. But the moral of the story is use a CalABLE account. This is where you want to set it up. All right, so we already talked about you can put in up to $19,000 a year. The ABLE account can hold up to $100,000 and somebody can still get their SSI benefits. If your ABLE account goes over that $100,000 limit, your SSI is suspended until you spend it down below $100,000. So most people have an ABLE account of less than $100,000. But if you're not receiving SSI, then maybe you're just receiving Medi-Cal, for example, then you can put up to $529,000 in your CalABLE account. Now, it's going to take a long time to get there, right? Because you can only put in 19,000 each year, but that's how much you can get to. Now, one drawback of the ABLE account is that it only holds cash. It doesn't hold, remember that slide where I said, hey, it can hold a house, it can hold retirement accounts. Nope, ABLE account only holds cash, and they have like 7 different platforms. Well, no, that's not right. 7 different, you can invest more aggressively, you can invest more conservatively. So you get to choose which level you want to be at, but you don't get to keep securities in here. It's not a place to creatively invest. It's going to grow slowly. Okay, we talked about the rollovers to the 529 plan. So how do you set up a CalAble account? First, you go to your favorite bank or credit union, and you get a checking account in the disabled person's name. Then you go on the CalAble website, okay, calable.ca.gov, and you enter the routing information and the account information of that account that you set up at your favorite bank or credit union. And you provide the beneficiary's social security number and the authorized legal representative's social security number if there's going to be one. And then the ABLE program is run by Vestwell. So Vestwell basically links to the bank where you're holding them, where the money is custodied. Vestwell keeps track of everything. To get money out of the ABLE account, you can get a prepaid Visa debit card. Not the most flexible way, but it's a lot better. Before you had to use a check. So this is an improvement. All right, so here's another chart that you can go over in your spare time because I do want to leave some time for questions. But basically, we're comparing when might you use an ABLE account, when might you use a third-party special needs trust, and when might you use a first-party special needs trust. And again, this is all on my YouTube channel as well. Okay, so that's a little bit about that. Okay, so this is our firm, yay. Again, we're in Palo Alto, but we serve all of California. And just to let you know, we don't do public benefits applications. So if you're looking to apply, that's not something that we help with, but we do help with estate planning, special needs planning, and trust administration. So feel free to reach out to us. We also have a trust maintenance program. Once you've signed your trust, we'll be with you for the long haul. And here are some QR codes that you can use if you want to get slides from the presentation and be added to our monthly email list. And then also, if you'd like to set up a time with us, that's the one on the right. Okay, so that's what I have today. So I'd love to open this up to questions. Maybe we can take a look at the, where is it? Oh, there we go. Okay.
Yeah, you can go into the Q&A, Ellen, and grab a couple of questions. We have about 5 minutes for questions.
Oh, okay.
We need to start wrapping up.
Okay, great. Okay.
One question before
Yeah, please.
you do that. A lot of times, families are not able to afford, as hiring a financial planner. So let's start there, and then you can grab some questions after that. What would you suggest for someone that's on a budget?
Okay. So there's a few ways to do it. There is one financial advisor who he has a website called Special Needs Map. And basically, I think you spend like $250, which it's still a fee, but it's not nearly as much as a financial advisor. And you can go online and enter in your child's information, and it spits out the number that you might need. Now, it's intended for professionals, like financial advisors and planners. So I don't know if you need to like pretend like you're one, or like don't say, "Hey, Ellen Cookman sent me your way," because I might get in trouble. But that's one place that you can go to get a better idea of how much might you need for the long term.
Okay, great. Thank you for that resource. All right, so we have a few minutes if you want to grab a couple of questions out of the Q&A that feel like what a great
Sure.
presentation.
Yeah.
You shared so much with us.
Oh, thank you. Okay, one question. Can my adult daughter who has severe anxiety qualify for CalAble? Yes, as long as you can get a doctor's note saying that your child became disabled before age 26 or next year, age 46. So again, it's very easy to qualify for an ABLE account. Um, okay. Does the money that I put into the CalAble, is it free of tax? So it's not like a retirement account. For qualified retirement accounts, you can put in pre-tax money and then you have to pay the tax on the back end. This is different. This is money after your after you've paid your income taxes. That's the money that you put in. So that might be what that person is asking. Um, if the disabled child is working and does not have Medi-Cal or Medicare, yes, they can have a CalAble account. Yes. Can it be used to purchase prescription medications that are cannabis-based? Probably not. Or controlled substances. If it's legal federally, then it would be illegal. Otherwise, you probably are not supposed to use it that way. Boy, a lot of questions in CalAble. Can the funds in CalAble be used to pay for healthcare? Yes, it can be used to pay for anything. Yay! And can we have your YouTube channel information? Of course. So that's
I think we put that in the chat already.
okay. Yeah, that would be great. It's just type in Ellen Cookman Law and you'll find it. Are you required to inform Social Security about the amount in the CalAble account? During redetermination, every year or two, they might ask, and then you need to disclose it, but it shouldn't interfere with your benefits.
Okay, good to know.
Um, oh, this is a very good question. Okay, and maybe we can end on this. After the beneficiary of the special needs trust dies, what happens to the money? Oh, wait. Let's talk about what happens to the money in the special needs trust, and then let's talk about what happens to money in the ABLE account. For a special needs trust, when you draft the special needs trust, you spell out what happens to that money when the beneficiary dies. So you actually have to kind of preload that information. That is different than what happens to the money when the beneficiary of a CalAble account dies. If that beneficiary of the CalAble account has a disabled sibling, it goes to their disabled sibling's CalAble account. Other than that, it goes to their heirs. There's no beneficiary designation form for a CalAble account, which is really unfortunate. But the reason for this is that most states have a reimbursement claim, and so they need that money to be available for their Medicaid program to come bring that reimbursement claim. California, we've waived this, but it goes into your state. But here's the thing, as long as the ABLE account is under about $200,000, there's going to be no probate. You can just get there's like a one-page form that you can, work with an attorney to do. And basically it goes to the heirs. So if the parents are still alive, it goes to the parents. If there's any kids, it goes to the kids. Otherwise it goes to the siblings. So there's kind of it's a weird word, order of sanguinity, the order of where things go. Okay.
Okay, wow. I am blown away. That was a wonderful presentation. Thank you, Ellen. There's still so much I need to learn, and I'm so glad that you were able to join us today.